And if anybody has not seen it, do go to his article in Spectator on the engineer's case. It is wonderful to have someone so young showing such interest in what is still a very crucial case in the development, or the decline rather, of our federation. Tonight, I'm to talk to you about the Palace Letters, and I've given my talk a subheading, The Search for the Silver Bullet. Those of you who are old enough will remember that when you were children, there was a radio serial called The Search for the Golden Boomerang. It was all about Aboriginal people and a lost Aboriginal tribe, this in an allegedly racist country. But let me go back to what I'm here for, and that is the Palace Letters and the search for the Silver Bullet. I'd like to make 10 comments, 10, I hope, brief comments. First, the real issue in the case, or rather the legal issue in the case. The legal issue in the case brought by Professor Jenny Hocking against the Director General of the National Archives was to get access to certain letters between Sir John Kerr and the Queen, referred to as the Palace Letters, which had been deposited at the National Archive by his secretary, Sir David Smith, on Sir John's instructions. And the question was whether Jenny Hocking could have access to the records. The Director General of the National Archives saying they weren't Commonwealth records for the purpose of the Act, and therefore not accessible. That case went to the Federal Court, and then to the full bench of the Federal Court, and finally to the High Court, when finally the High Court, by a majority with one dissentient, found that they were Commonwealth records. Now, I find the case going to the High Court curious, to say the least. It was surprising. 2 courts had already decided the case against Professor Hocking. The High Court only agrees to hear about 10% of requests for special leave. It was obvious that the whole point of this case was to promote the Republican cause. And it seemed to me that there were more important issues for the court. In particular, I'm well aware of a case involving the standard required in the defense of truth in defamation. And this may well become a pretty important case when and if Ben Roberts-Smith's case comes on for hearing as to what standards have to be applied there. And there's also the Pell case. In the Pell case, the High Court showed extraordinary nervousness in granting leave. In fact, they delayed the decision in granting leave to appeal until they finally actually heard the appeal. So why they rushed in this case, and why the taxpayers have now been landed with the cost of some very expensive litigation for papers which are of historical interest, which would have been available in due course, I am not completely sure. A member of the Samuel Griffith Society, a long-standing member, who was very close to Sir John, tells me that he always wanted them to be read. He just wanted the proper conditions to be applied in relation to correspondence between himself and the Queen. And normally, these are not released during the life of the Queen. Well, my second point is the real issue in this case. Professor Hocking is a member of the National Committee of the Australian Republican Movement. And I don't think it's unfair to say that she has been driven, if not obsessed, with the belief that, without any evidence whatsoever, that both the Queen, not as the Queen of Australia, as the Queen of the United Kingdom, and the British government were implicated in the dismissal of Gough Whitlam. So much so that she argued that a visit, what was probably going to be a courtesy visit, we don't know whether it actually took place, a courtesy visit or the itinerary for a courtesy visit of a senior British diplomat to the Governor-General, Sir Michael Palliser. She argues from this, without any evidence whatsoever that the British and the Australians and Sir John Kerr were just discussing how to get rid of Gough Whitlam. She told the Sydney Morning Herald, "What is in those files is, to my mind, volcanic." There was certainly an obsession there. The idea was that this would provide a silver bullet. It would provide the grounds for the removal of the Crown from the Constitution. Just a brief words on what those who want to remove the Crown want to do. They want to remove the Crown. Most of them want it removed from the federal Constitution. It's thought to be easier to do if you just do a staged approach, and that the states would eventually roll over. There is an argument that this requires all states to agree, not just the people of 4 states. And there's a warning by Premier Barnett, the former Premier Barnett of Western Australia. And he was a Republican. He has warned, and it's on record in a video, which is on an ACM site. He has warned that if Australia did change the status and remove the Crown, that all bets are off and the whole thing has to be looked at again. And there's no guarantee the Federation will hold together. As Harry Gibbs raised that idea, the need for a consideration as to whether, for such a fundamental issue, the 6 states had to be in agreement. There is, incidentally, a minority view as to how to change the Constitution by a Victorian MP, federal, of course, Julian Hill, who's argued a very simple way to circumvent the referendum. He argues you can do this merely by changing the Act of Succession so that the successor to the Queen becomes a person to be chosen by the Parliament. Well, so much so for the real issue. The third point I want to make is that since the 19th century, all Australian Republican movements have not been so much about a republic, but about something else. And there have been 3 major ones. In Trumpian terms, you could call them all fake Republicans. The first was in the 19th century, and it was about the gold rush, particularly in New South Wales, but to an extent in Victoria, and how to stop Chinese immigration. Immigration was considered an imperial matter, and there was a strong movement in New South Wales led by the Bulletin for the formation of a republic based on the southern states of the United States, which would be essentially racist. The second big Republican movement was Bolshevism, when the Communist Party was formed. It never made much of an electoral impact, except I think 1 seat in Queensland. But it did make a significant impact in relation to the trade unions, the end of the war, Second World War. I think a majority of the ACTU was communist, and they made a strong impact indirectly in the ALP, where there were some members, some leading members. So one minister in the Whitlam government was also a member of the Communist Party. And finally, we have the Keating-Turnbull Republic, essentially to get rid of the House of Windsor and putting the head of state, this seemed to be perhaps the real purpose, putting the head of state under total political control. It would have been, as famously said at the time, the only republic, not only in the world, but the only republic in history in which it would have been easier for the Prime Minister to sack the President than his driver. He could sack the President without grounds, without any notice whatsoever, and without any right of appeal. That was the model which extraordinarily went to the Australian people and received such strong support, for example, in the media, among some members of the legal profession, and consequently then 45% of the public. My 4th point is that Jenny Hocking and the Australian Republican movement overwhelmingly reject any of the successful Republican models which are the product of Anglo American civilization. The word republic is a Humpty Dumpty word, like multicultural. As you no doubt recall, Humpty Dumpty said, when I use a word, it means precisely what I want it to mean, nothing more and nothing less. The republic can mean all sorts of things. As you know, it is just Latin for public thing. In the Anglo American world, however, it has taken on a meaning because of the Glorious Revolution and the events which preceded it, and the American Revolution. In the Anglo American world, it has a particular meaning. It means a society in which it is accepted, it is self-evident that man was endowed by his creator with certain unalienable rights. Note that, endowed by his creator, meaning it's a question of natural law. It's not a matter for politicians to give those rights to the people. Secondly, it's a government, it's a society in which the government is limited and in particular subject to checks and balances, and especially through the separation of powers done under a constitution which Bolingbroke described as that assembly of laws, customs, and institutions by which the people have agreed to be governed. As I say, government requires agreement by the people, even under some of our premiers. The very first example of a republic, strangely, was something not called a republic. It was a result of the Glorious Revolution. Montesquieu saw it as a disguised republic, because instead of the traditional monarchy, this was a monarchy where the separation of powers was invented and applied. It was different. I call it Constitutional Monarchy Mark I. It was different from the one we know because the king or the queen was the executive, and the ministers had to have the confidence of the king, not the confidence of the house, the confidence of the king. That lasted for quite a time in England and was a disguised republic. Across the Atlantic, on the other side, after they obtained their independence, Hamilton chose this model as the model for the American Republic. He didn't choose what we would know as a form of constitutional monarchy now, that is with a government which is responsible to the House. He didn't choose that. That didn't exist. He couldn't choose that. The debate that Hamilton had at Philadelphia was whether the executive, who would replace the king, would be a single person or whether they'd have more than one, say three, two, as in the Roman Republic, or three. He argued strongly, and this was accepted at the convention, that the British model should apply. You would have a king who would be elected through what is called the Electoral College now. The Senate would take a longer term view, as the House of Lords does, and the more popular House of Representatives would reflect the views of the people in a shorter term view. The three models which we know, and extraordinarily, the Australian Republican movement chooses none of them. It brings in an alien one, not known anywhere else in the world, but rejects everything that we have known previously. It's interesting to reflect on this, particularly on the American model, that at the first of the conventions to establish our federation, it was proposed in committee by the New Zealand representatives, they were represented then by Lord Grey, that the Governor-General be elected. And that was strongly opposed by Sir Samuel Griffith and never prevailed. The third form of republic is that which we have now, constitutional monarchy Mark II. That only emerged by the time of Victoria. And under this, the ministers no longer must have the confidence of the king. Now they have the confidence, they must have the confidence of the lower house, the House of Commons. This was an interesting development because it brought in responsible government. The responsible government meaning the government had to be responsible to the lower house and lost office if it didn't retain that responsibility. What also is interesting is that in 1839, in the Durham Report, I see that in America there's going to be another Durham Report, which may be just as important. But in the Durham Report in 1839, that system of government, responsible government, where the governor or the governor general or the Queen doesn't actually choose the ministers, they don't have to have confidence in her, where those ministers have to have the confidence of the lower house, was recommended for introduction into Canada. It was, and then it was introduced into the Australian colonies and then other settler colonies. The problem with constitutional monarchy Mark II, and this is relevant to the debate over a republic and the reserved powers. The problem with it is that it breaches the separation of powers. Montesquieu saw three separate powers: legislative, judicial, and executive. Under the model of constitutional monarchy we now know, with responsible government, the lower house and the cabinet are in bed together, and as long as the cabinet's in power, they control the lower house. The whole idea of the separation of powers is weakened. It is extraordinary. It's an interesting thing about our constitutional systems and our legal systems that they evolve. And just as the separation of powers was taken away, at least partially, a new idea developed, and that was of the crown as the constitutional guardian. The crown, now no longer political, now no longer divisive, now no longer a party crown belonging to one side or other, favoring one side or the other. You now have a crown being a leader above politics, who becomes the constitutional guardian through the exercise of the reserved powers. These are powers which normally may be exercised on the advice of the minister, but in circumstances relating to the protection of the Constitution, they are then exercised at the Governor-General's discretion, the Queen's discretion, the Governor's discretion, and so on. This has been exported to other countries. It's worked well, interestingly, in Arab countries and in Afghanistan during a period. The French tried it. The French have tried everything. The French tried it in the Third and Fourth Republics. Unfortunately, it did not end well in either circumstances. India is a great constitutional republic, but when it became crucial as to the role of the president, that is, when Mrs. Indira Gandhi declared an emergency, it was completely unjustified. She was only trying to hold on to power and avoid being prosecuted. When she got the president to declare an emergency, she reminded him that the Congress Party made him, the Congress Party appointed him. I would think a Governor-General, influenced by the model which has been established by the Queen and her predecessors, right back to Victoria, a Governor-General would do what a Governor-General should do. And I think that was demonstrated by Sir John Kerr. He wasn't loyal to the person who appointed him, or effectively appointed him, Gough Whitlam. He was loyal to the system. And I think that was the weakness shown in the Indian situation. The ARM, the Australian Republican Movement, doesn't want any of those republics. It wants a republic in which the president will be completely under control and under the thumb of the Prime Minister. Just to give you an idea of what some leading Republicans like, I found something by Paul Keating. Paul Keating, in many ways, is the father of all this mess because he introduced it to the Parliament, but he said at La Trobe University, interestingly, again in Victoria, everything seems to happen in Victoria, he said that in relation to the government of the People's Republic of China, that it was the best government in the world in the last 30 years, the best government in the world in the last 30 years. I come to my fifth point, and I think my time is going ahead quickly. My fifth point is that the Palace Letters, a silver bullet, were really to be associated with a second silver bullet. The reason why the ARM needs silver bullets is that in the 90s, they began to provide more and more ridiculous reasons for Australia changing its constitutional system. We were told this was important in relation to trade, as though people trade with countries according to their constitutional systems, which seems to me to be an extraordinary proposition. But Al Grasby and Neville Wran promoted the idea that the constitutional monarchy created unemployment and a republic would cure unemployment in Australia. Reasons became sillier and sillier. They then woke up to the head of state, and they chose the head of state as the silver bullet. The term head of state can be used in two ways. Firstly, it's an office under public international law, a diplomatic office under public international law. Secondly, it can be used not as a legal office, but as a description of a legal office. There's no doubt that the head of state for diplomatic purposes is the Governor-General. All governments hold him out to other governments as the Governor-General. The only importance in international law of a head of state is that a head of state is entitled to certain courtesies, 21-gun salute, for example, instead of 18 guns. And in addition, a head of state has immunity from the local jurisdiction. That all flows from the Treaty of Westphalia. Heads of state used to be called princes in the 20th century. With the emergence of republics, they came to be called heads of state. As I said, it can also be used as a description of the constitutional office. But fortunately, our High Court has solved that for those who are worried about the head of state. The High Court said in 1907, in the case concerning South Australia and the Senate, the High Court said that the Governor-General is the constitutional head of the Commonwealth. But that still remains an important silver bullet for the Republicans. And I've checked opinion polls, essential opinion polls. When they put in, which they did, they put it in after the ARM commissioned them to do a poll. When they add the words head of state, so that the question is, are you in favour of a republic with an Australian as head of state? Once they add those words with an Australian as head of state, the yes vote goes up about 8%. So you can see why the Republicans are pushing that. The term head of state came to be introduced into some domestic constitutions, not ours, not the Americans, not the British, not the Canadian. The first one to do this was General Franco in 1936 and Marshal Pétain in 1940. So it was a favourite, curiously, with the fascists. My sixth point is that the Palace Letters, at least in its first part, are being used to suggest that the 1975 dismissal was wrong. It wasn't wrong. It was the standard rule in all parts of the British Empire that if supply were rejected, the Prime Minister must immediately either advise an election or resign. Every Prime Minister knows this, or should know this. Mr. Whitlam knew this. Speaking to Parliament in 1970 in support of a motion in the Senate to bring on the rejection of supply against the then coalition government, he said this: if a money bill is defeated, the government goes to the people to seek their endorsement of its policies. So what Whitlam was saying is, if there's a rejection of supply, the government must go to the people. And to lend support to that, he had Senator Murphy table a list of all previous attempts by the Labour Party to reject supply. There were, believe it or not, 169. They're there in Hansard, Labour attempts to reject supply. And the reason they weren't able to get supply rejected was because the DLP would never join them in the Senate in rejecting supply. So all 170 failed. The coalition tried this twice. In 1973 and 1975, both succeeded. And the rejection of supply was done in most states, especially Victoria. Victoria figures a lot in political matters, and Victoria was very keen on rejecting supply, but it was done away with, obviously, by some agreement between the principal parties in 2005. My seventh point is that the ARM has concluded that their strategy since the referendum has been a failure, and the Palace letters offer a wonderful opportunity for a new strategy. The old strategy was to have a series of plebiscites, which you'll remember at the last conference of Samuel Griffith, the New South Wales Silk, Alistair Henskens, who was also an MP, argued is unconstitutional. Each plebiscite would persuade the people to come to some form of a republic, and then that model would be put. The very first plebiscite would be, are you in favour of Australia becoming a republic with an Australian as head of state? Again, an attempt to build up the yes vote. That can only be described as vandalistic because it invites the people of Australia to vote against their constitution, give a vote of no confidence in the constitution without immediately changing it, which is the whole idea of Section 128. Well, after 20 years, it dawned on the ARM that they really needed a new strategy, which I find rather exhausting, that you keep to a strategy which kept on failing for 20 years. Anyway, they've got a new strategy, and what they've got to do is bring the real Republicans on side. The real Republicans are that small group led by Clem Jones and Ted Mack at the convention, who argued that the president should be elected by the people. And under Senator Minchin's plan to fill the vote no committee for the referendum, based on how many votes you got, they got 2 seats on the vote no committee, and ACM, Australia's Constitutional Monarchy, got the other 8 seats. And that worked out well. They were good allies and reliable people. I don't think that many people were swayed by the vote. I think the view was more among Australians, if we're going to have a president, we'll elect the president. Now, the problem for the ARM is that their conservative elements, particularly the politicians, are strongly opposed to direct election. They say they'd rather have the monarchy than a republic in which the president is directly elected. And there would be serious problems with a directly elected president, because with a directly elected president, he might not take notice of the conventions which surround the crown and take his powers seriously and decide to exercise them. So much so that I wrote a piece which didn't cause much interest, but when Dick McGarvey agreed, a lot of interest was taken. This was one model at the convention. What we both argued was that this would turn Australia into a French-style Fifth Republic with a strong president, inadvertently, without thinking about it, with the potential for strong disputes between the Prime Minister and the government. My 8th point is that it's long been obvious that the ALP, Australian Labor Party, has outsourced its policy on Republican change to the Australian Republican movement. I don't think they're really separate organisations. And if you go to the 2019 election, and if you read the national platform, and you need a lot of time to read the national platform because it is a very wordy document. But if you read the national platform, you'd see that in relation to the Republic, there would have to be a number of plebiscites, just like the ARM. Now, a few days ago, strangely, Anthony Albanese's draft platform, which he'd been working on, turned up in the Australian. Somebody leaked it. And it seemed to be a very convenient leak because it allowed Mr. Albanese to test the waters. So I have suspicions about that leak that I don't know. But if you look at chapter 6, and I can tell you I didn't read chapters 1 to 5, and I didn't read all of chapter 6. It's called Democracy. It opens with these chilling words. Labour believes that the Constitution is a living document. A living Constitution. That's how the American Supreme Court created parts of the Constitution which didn't exist. In Roe v. Wade, for example, they decided that the Constitution protected abortions. There's no such thing in the Bill of Rights. It's pure imagination. But they inserted that because they say that the Constitution is a living document. So that puts anyone who's a constitutionalist on their guard. What's very interesting is clause 8 of chapter 6. You can see how hard I was working, having to read a whole wretched chapter. 8, Labour supports and will work towards establishing an Australian republic with an Australian head of state. I looked at that and I thought, but that's what they're saying at the ARM, the same words. They've dropped the plebiscites, which tells me they're working together. Now, it's irrelevant, but to what we're talking about, I think I should tell you this, because you ought to know this. Labour believes, they say in the next sentence, that other constitutional reforms, such as fixed 4-year terms, the recognition of local government in the Constitution, should be progressed through a new and independent Australian Constitutional Commission. An Australian Constitutional Commission. Now, I'm reliably informed that the major and crucial qualification of being appointed to Mr. Albanese's Constitutional Commission is to not be and never have been a member of the Samuel Griffith Society. I think that's probably a condition. No one told me that, I dreamed that up. My 9th point is, the palace letters confirm that Kerr acted impeccably. The Prime Minister could not constitutionally stay in office. Whitlam's choice, he had 2 choices. He could recommend a general election or a double dissolution election, because that was available, or resign. Those were his only choices. His proposal for a half Senate election could not be taken seriously, and I doubt if he meant it seriously. The new senators wouldn't take office until the next 1st of July, about 9 months later, 8 months later, and a number of governors had been advised by their state governments not to issue writs, so no election would probably be called. Another problem was the proposal for bank credit so that Whitlam could govern. This was clearly unconstitutional and not available. And the dismissal was in fact discussed between them. It is said by those critical of Sir John Kerr that he didn't warn Whitlam and he had a duty to warn Whitlam. Well, the dismissal was discussed between them. Sir John says 4 times. Mr. Whitlam denies 3 but admits to 1. That was a dinner for Tun Abdul Razak, the Prime Minister of Malaysia, who asked about the question because he just arrived in the middle of the constitutional affair. The political crisis wasn't a constitutional crisis, the political crisis. And Whitlam replied, he says flippantly, it would all depend on whether I get to the palace first or Sir John dismisses me first. He says that was flippant, but Sir John naturally took it seriously. He's also said, and I remember Sir William Heseltine, who was the Queen's private secretary, who addressed the conference of ACM, he said that a number of people at the palace thought that Sir John could have delayed. Well, he couldn't. It's very clear from the Electoral Commission that the last date on which preparations could be made for the election was the 11th of November. Mr. Whitlam had asked, coincidentally, to see him on that day. And it was the last day on which you could hold an election before Christmas, before the schools broke up, and you wouldn't have the people that you needed to work on the polling booths, both for the Electoral Commission and the parties. It was the last day. The other point on which Kerr was attacked is over getting advice from the judges. There's a large number of precedents of governors general seeking advice from the Chief Justice and other judges. The question was most unlikely to ever come before the court, so it was quite proper for the Chief Justice and Mr. Justice Stephen to give advice. A few years ago, I met a law lord, Lord Wilberforce, and he commented on this and he said, well, it's very surprising. The palace constantly seeks our advice, whether they do this under Mr. Blair's Supreme Court, which seems to have mucked the whole judicial system up in England. I don't know whether that still continues. My 10th and final point is, it's clear, it's without doubt, as Sir John was at pains to ensure, he really went out of his way to make this very clear. The Queen, and certainly not the British government, the Queen, it was the Queen of Australia, was in no way implicated in the dismissal of Gough Whitlam. And incidentally, that was Gough Whitlam's belief. Gough never, ever thought that the Queen was involved. So, and just finally, that means that Professor Hocking and the Australian Republican movement and the Shadow Attorney General, who made some, I thought, inappropriate comments about the role of the Queen in this, Shadow Attorney General Mark Dreyfus, QC, and the Shadow Assistant Minister for an Australian Head of State, Matt Thistlethwaite, made comments for which they should have vast amounts of egg on their face. How wonderful it is that the founders did put into the Constitution requirement that any change to the Constitution be approved by the people nationally in the states. Just very briefly, Quick and Garron say that this was put in to prevent change being made in haste or by stealth, to encourage public discussion, and to delay change until there is strong evidence that it is desirable, irresistible, and inevitable. A very good description of why they put that provision in the Constitution and how well it works. It could have been, as in some countries, a supermajority of politicians, and I wouldn't trust them to change the Constitution. That's what we would have got all sorts of things had that happened. It was very good that our founders were wise enough to decide on making it a matter for the people to decide on whether constitutional changes should take place. This case, I don't think, should have ever reached the High Court. Very few people on the Republican side, Paul Kelly and young Bramston, didn't think that the Queen would ever be shown to be implicated. Nobody thought that. It was a waste of time and money. At least we do have the advantage of being able to read some very interesting letters which are there on the website of the National Archives. And I do appreciate the opportunity of being able to talk to you about this on this occasion. Xavier.